Well, thank you so much, John, for that lovely introduction, and also to UNH Law School for sponsoring this event. I also wanted to thank all of you for participating today. I actually am originally from New York and I teach in Vermont, but I live in New Hampshire. And I'm just delighted to see all of you, and I'm grateful to you for giving up your Saturday to come learn more about the Constitution and for contributing so much to our democracy here in New Hampshire. So hold on a second, I have to load up my slideshow. Let's see. No, it's here, it's going to work. Slideshow, beginning. Okay. So today I'm going to be talking to you about states' rights, federalism, and criminal justice, and in particular about the conflict that is brewing over marijuana legalization. And sort of to take this to a more layperson's level, what I really want to talk about is the relationship between the state and federal criminal justice systems. We have these two parallel criminal justice systems in our country, and so I want to talk a little bit about what they each are, what they're empowered to do, and really what happens when they conflict with each other, because as we're going to see, they have a fair amount of overlap. They can sometimes criminalize the same things, and sometimes they will, when they're coming into conflict, they may actually decriminalize certain things, as we're going to see with marijuana. And there you have the marijuana plant, which is going to be the subject of this big conflict. So at the most basic level, we have, as I said, these two parallel criminal justice systems, and I'm sure that's something that we're all familiar with. We know that there are federal agencies such as DEA, FBI, Border Patrol, TSA, and a number of these agencies that deal primarily with federal crimes and issues. They work with federal prosecutors, such as I was when I was working in New York, and they enforce federal crimes. We also, at the same time, have a parallel state system. And so that would be, for example, your local sheriff, state troopers, and they would tend to work, for example, here in New Hampshire with county attorneys' offices, and they would be enforcing state crimes. And now I know we all know about this at some basic level, but probably you all haven't devoted a lot of time to thinking, what's a federal crime, what's a state crime, and what is the constitutional basis for those two systems to interrelate. So that's what we're going to talk about today. And that's something that I've spent a lot of time thinking about, because when I was a federal prosecutor, I worked in an area where there was a significant amount of overlap. And that's because I worked in a district that had the ports and the airports that service New York City. And so we did a lot of drug cases. Drugs are something that are criminalized both at the federal level and the state level. So how do we draw that line between saying this drug case is a federal crime to be charged by the feds, and this drug case is a state crime? Well, that used to be part of my job. I used to do intake, and I would have to decide, are we going to prosecute this federally or send it to the state? And when it comes to drugs, a lot of that is simply a matter of quantity. Was it federal weight or not? Big cases were federal cases because they're often dealing with, boatloads or plane loads of drugs that are getting imported into the U.S. Small cases, personal use amounts and so forth, people who were just selling a little baggie on the street corner was going to be a state case. But why is that when we look at the Constitution? Well, at the most basic level, the difference between a federal crime and a state crime is which legislative body has enacted it. And that sort of begs the question, but it's important to realize that the U.S. Congress in Washington enacts criminal laws, and so does the State House here in Concord. They enact the New Hampshire state laws. And so at the most basic level, there's a whole body of federal crimes that's written down in the Federal Criminal Code, and every state has has its own criminal code as well. There's actually 52 criminal codes in the United States because all 50 states, the federal government, and the District of Columbia have their own written criminal codes. And all criminal laws are statutory. There's no what's called common law of criminal law. It's not just like, oh, we all know it because it's been done since time immemorial. It has to be written down in the code book, and the purpose of that is to give citizens notice of what kinds of conduct can subject them to serious sanctions such as fines, jail, and potentially even the death penalty. So we require, as a matter of due process law, that crimes be written down in the code book. So we have the federal code and we have the state code. Now, to talk about how these two systems interact, we need to look to the Constitution. And so that's what I'm going to be talking about today. What does the Constitution have to say about what can be a federal crime versus a state crime, and which one is going to take priority when they come into conflict? And again, as I mentioned, this is generally a really interesting question, at least to me, but I think it's becoming really interesting to people because of this issue of marijuana legalization. So let me just talk about that for a minute. As you're probably aware, because it's been covered fairly extensively in the press, Colorado and Washington State, a couple of Tuesdays ago, voted to legalize personal use of marijuana. And I'm not talking about medical marijuana now, because a number of states, in fact 18 states and growing, had already had medical marijuana statutes. We don't have one here in New Hampshire. Vermont has one, and a lot of other states have them. And those, as you're probably aware, would allow use of marijuana by chronically ill persons, and it's very specifically defined what illnesses it can be for. And it's also requires a doctor's prescription and so forth. But marijuana was allowed for medical use for a number of years now. However, during that entire time, it's still been illegal at the federal level, and that's caused some conflict, which I'm going to talk about in a minute. What's different about what happened on Election Day is that 2 states have now legalized marijuana for recreational use, and both of those statutes allow people to possess an ounce or less of marijuana just for recreational use. They do impose age limits. They do impose some limits on where you can smoke it. And in terms of cultivation and sales, they set up an entire bureaucracy for regulating and taxing the cultivation and sale of marijuana. So generally, it's run sort of like alcohol sales, slightly more restrictive. For example, in the Washington statute, the state liquor board is in charge of marijuana distribution just the same way that it's in charge of alcohol distribution and regulation. So these are fairly revolutionary statutes in that they're doing something that has never been done before and something that is still illegal at the federal level. So what does the Constitution have to tell us about that? Well, the first thing I want to talk about is the idea that our government, our federal government, is one of enumerated powers. And I'm sure that Professor Massey is going to speak to this more extensively than I will. But the bottom line is, when the federal government makes criminal law, it does not have broad power to do so. It can only do so in a fairly limited way because it must rely on its enumerated powers. And there is no broad police power granted to the federal government under the Constitution. That power is reserved to the states. So when the state of New Hampshire makes criminal laws, it does so acting under its police power that allows it pretty wide leeway to criminalize whatever conduct it would see fit and to do whatever the legislature feels is right with regard to criminal laws. However, when Congress and the federal government acts to make criminal laws, they are acting under the commerce power. And this is something we've all heard a fair bit about recently because it's been at issue, for example, with President Obama's health care law. How broad is the commerce power? What does that allow Congress to do? Well, generally, the commerce power is the source of Congress's power to act in many different areas. For example, civil rights law, healthcare law, certainly any economic regulation. But it's also the source of Congress's power to act when it comes to criminal law. And why is that? It's because crime affects interstate commerce. And I think that's sort of an obvious common sense proposition, but we know that if you're trafficking marijuana across state lines, that's essentially an economic activity, just like selling any other product. Other types of crimes can also affect interstate commerce. And so just briefly reviewing the text of the Commerce Clause, it says, Congress has the power to regulate commerce among the several states. And that's what we're interested in here. Now, with other types of crimes, often you're relying on the interstate nature of the crime to create federal jurisdiction. So, for example, prostitution is a state crime. Transporting women across state lines for purposes of prostitution may be a federal crime. Kidnapping, for example, can be a local crime if the victim is transported across state lines, or fairly recently there was an amendment to the federal kidnapping statute that said if facilities of interstate commerce are used, such as telephones or the internet, to facilitate the kidnapping, it would come under Commerce Clause jurisdiction. So when we're sort of whacking up what's a federal crime and what's a state crime, we have to look at the Commerce Clause, and that's how we decide whether the federal government has power to criminalize something. Now, interestingly, these guys have already spoken on the issue of marijuana because they were asked to rule on a medical marijuana statute in California, and this was back in 2005. So actually it was this is the current court, slightly different justices at the time, but many of the same justices. And they had to look at a case in which two individuals in California had been growing marijuana for their own personal medical use in a way that complied with California's, I think it's called the Humanitarian Use Act or something to that effect, their medical marijuana statute. And those two individuals made a Commerce Clause argument. They argued that they were essentially growing marijuana in their own backyard. They were not selling it. And therefore, when the federal government came in to prosecute, that the federal government had no authority to do so because it was outside Commerce Clause jurisdiction. Well, the court disagreed with that. The court said that any time you talk about a commodity, essentially, even if it's not being sold into the marketplace, it's essentially displacing other marijuana in the marketplace. And because of that, I mean, the argument is, and this was an interpretation of a much older case, a Depression-era case that had to do with homegrown wheat and whether or not homegrown wheat could be subject to any federal regulation. And the court basically said anytime you're growing products that could be put in the marketplace, that is an act of commerce, essentially. And so the government is allowed, or the federal government is allowed, to make a law that says marijuana shall be illegal, even if the individuals who are acting under the California statute are not actively selling the marijuana. They can still be subject to that federal law. So what's the bottom line here? Well, we have a situation where the states of Washington and Colorado, acting under their police powers, have decided to legalize marijuana for personal use. We also have a situation where the federal government, under the Federal Controlled Substances Act, has said that marijuana will be illegal for personal use and for sale. And the federal government, according to the Supreme Court, is fully entitled to do so. So what happens to the individual in Colorado who decides that they want to sell marijuana under the new new legalization statute in Colorado. What happens if the federal government decides to come in and say, too bad, you knew this was illegal at the federal level, we're sending you to federal prison? Well, the bottom line is that the Supremacy Clause says that the federal government is entitled to do that. The Supremacy Clause basically decides what happens when these two bodies of law come into direct conflict. And it says that this Constitution and the laws of the United States, which shall be made in pursuance thereof, meaning laws like the Federal Controlled Substances Act, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution and laws of any state to the contrary notwithstanding. So what does that mean? It means that if you're in Colorado and you decide to sell marijuana, and you see a state trooper, you don't need to be worried, but if you see a guy in a DEA jacket, you should watch out. So thank you.